All right. There's an expectation that a jury could be seated as early as tomorrow in the Alex Murdaugh murder. That means that we're going to have openings, and that means we're going to have some drama early on because there's a big fight about what should get in here as material to put before the jurors. What should be the evidence in this case? Now, remember also in the Idaho murder case, there's drama even before the trial begins because now we have a question about the lawyer for the accused. Is he conflicted out, this lawyer? So let's bring back our panel. High-profile trial attorney Mark Geragos, high-profile prosecutor Christopher Darden, and the highest profile of them all, because she went viral for raising this question about the accused attorney, former FBI agent Jennifer Coffindaffer. First, we start with Murdaugh. Now, Counselor Darden, you say, hey, listen, they can talk all they want about who they want and that the one side wants older jurors so that they can like the family and the other side wants younger jurors so they don't know much about the family. But you say it only takes one to hang the whole thing. And so all of this is kind of guesswork. Explain.
Well, it is completely guesswork. Both sides are relying on potential jurors to tell the whole complete truth about their bias and about their knowledge of the family and their knowledge in the case. And, people can explain their bias, sit there and consider it, but ultimately, and especially by the end of the case, it may be that they're more biased than they ever thought. Now, you've got a defendant here whose family's been living in this community for decades and decades. I gotta say, I think that puts the prosecution at a disadvantage. You can't find anybody in that community that doesn't know the defendant or his family, or or knew his father or his children. It's a turkey shoot.
Now, Mark Geragos, you say it doesn't matter. At the end of the day, the burden remains the same. You got to prove it beyond a reasonable doubt, no matter who's in the box. Fair. You also beat me like a piñata the other night, saying how bad this ballistics report was and all this stuff that they want to get in. It's not going to happen. The judge today ruled that the ballistics evidence should come in. That witness should be able to testify. Surprising?
Well, I think it is, and I don't think, be careful what you wish for if you're the prosecution. I don't think this is helpful to them. I think it's going to backfire. I don't know, there's a ton of charges here, and a lot of times people believe and jurors believe that quantity equals quality, but at the same time, I think the prosecution's got an uphill battle in this case. I would build on what Chris says. This is somebody who has been known not just for decades, but for generations in this community. It's not like they were there necessarily prosecuting heavy-duty cases. It was more of kind of municipal violations, things of that nature. By all accounts, they generationally did a lot of good work, and he's got a top-flight defense attorney who knows that community well, and I think they've got an edge. And that's saying something, because usually in cases like this, it's the defense that's running uphill.
How big a deal is it, Mark, if we have to get a better understanding of what the judge is going to allow and not allow. But if it goes, if the judge takes the position of, let me let the witness testify, and then you can object and we can fight it out then once it's actually been material in the case. How big a deal is it for the prosecutor if the judge does not let the motive evidence come in of all the other things that were going on?
I think the judge will let it in, frankly. I mean, I think the kind of default saying most judges get, it goes to weight, not to admissibility. So they're going to say, let the jury decide. I'm going to let the jury give it whatever weight they deem appropriate, but I'm not going to preclude the prosecution from bringing it in. I just think, and like I say, I haven't done any formal focus groups. In my informal focus groups, when I tell people he murdered his son and his wife to deflect from what was then a $750,000 embezzlement. I just don't buy that. I think that there's a much stronger argument that this guy was a drug addict, maybe, or had gambling debts, one or the other, and somebody was trying to send a message to get him to pay his debts. I just don't buy that he would blow up the head of one son, and at the same time, very shortly thereafter, he was going to commit suicide or arrange to make it look like he got jacked so that he could get the insurance policy to go to his other son. I mean, in my opinion, it's a bridge too far.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find NewsNation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of NewsNation's fact-driven coverage.